and welcome to all the participants to this session about role of insolvency professionals. So just a quick feedback. I hope all of you are insolvency professionals or somebody else is also there. It looks all are insolvency professionals. So in a way, all of you are well aware of the role and responsibilities of an insolvency professional. Still, we will go through various provisions, key responsibilities, and discuss with important case laws to understand the impact of various provisions regarding the insolvency professional. First thing, IP is considered as one of the 4 pillars. What are the other 3 pillars? IBBI, adjudicating authority, and information utility. Unfortunately, COC is not considered as a pillar, but that's the most strongest pillar in fact. Out of the 4 pillars, IP is considered as the fulcrum, the person who is responsible for running the whole process. And what is the object of running the process? What is the overall object of running the process?
Revival of the corporate data.
Yeah, revival, of course, is the object, but doing it in timely manner, how does it make a difference? The idea is to have the maximization value, because if it is dragged, the values will deteriorate substantially. So that object is to be read as one object within the time frame resolution for maximization of the value of the sets of the corporate data. Now, IP, most of the people feel, and to some extent it's correct, that all the responsibilities are put on IP. And IP is the least powered person to influence the ecosystem in which we operate. As an individual or as a firm, because on one hand you deal with the promoters who had ample money but not paid the bankers. On the other hand, you have our legal system which is not very efficient or effective, where the cases drag on for years together, and then facing the decision-making process of the committee of creditors. So all these things make RP's responsibilities more challenging than what was thought of when the law was designed. As IP, you must have had experience in different cases, how difficult it is for the IPs to handle the situations when there are conflicting claims. The stakeholders' interests are contradictory to each other, and they try to influence the decision of insolvency professional. So we'll start with what was envisaged in the BLRC report about the role of insolvency professional, and what was considered important in terms of how an IP should function. Let me share the PPT first in the meantime. Please confirm that the PPT is visible.
Yes, sir, it is visible, but its screen is small, but you may increase the size
Yeah,
of.
I'll put it there. I'll also
Very
request
difficult.
participants to put their videos on so that we can effectively communicate. Because when the videos are not on, I feel whether the person is actively participating in or not. In case of questions to be asked or clarifications to be done. Almost everybody has put the video off except Mr. Sundaram. And Mr. Khattar is there, of course. Katur, sorry. This is the object, main object, in a time-bound manner for maximization of value of assets. And that's where most of the time IPs get a bang on their back, whatever may be the reason, but the ultimate responsibility is put on the shoulders of insolvency professionals. And insolvency professionals cannot influence the ecosystem as the government can do, as the adjudicating authority can do, as the regulator can do. So given that situation, the responsibilities are tremendous, challenging. Bankruptcy Law Reform Committee, because this was the first time an experiment was being done that a private professional was put in charge of the resolution process. The earlier practice was appointment through High Court in case of liquidation or winding up of the companies. So that was a great experiment in terms of putting the private professionals on such responsible positions. So that was discussed, like how they should function, what will be the effect of their functioning efficiently or inefficiently. And that was discussed, deliberated, and documented in that report. So I just taken out a few paragraphs which highlight the importance of the role of insolvency professional. The complex nature of the present day business world and the complexities of the laws and regulations are in their very nature capable of, giving great temptations, which may in turn persuade the professional manager to deviate from the path of right conduct. There are indeed too many snares and traps which might lure to deviate from the right path. Professional has to exercise great restraint in not falling a victim to these lures. So what was clearly envisaged was a situation if the IPs do not perform in the manner as prescribed or as expected from that. And rightly pointed out, since the IP is made in charge, he is in the control of the corporate debtor. He is the decision-making body, replacing the board of directors. So like we have the same saying, power corrupts and absolute power corrupts absolutely. So similarly, this was expected that like if there is a temptation in the professionals while they function for resolution, then it will be a difficult situation. So they should exercise the greatest restraint for not falling in a victim of these lures. And that's the reason the code of conduct for insolvency professionals is very, very stringent. And at every instance of any wrongdoing by any insolvency professional, suitable amendments are being done in the code of conduct regularly. And as compared to other profession, this is more stringent in terms of compliance, in terms of reporting, and in terms of punishments for deviating from the path prescribed. The BRC report continues, the role of IP is thus vital to the efficient operation of the insolvency and bankruptcy resolution process. A well-functioning system of resolution driven by IPs enables the adjudicator to delegate more and more powers and duties to the professionals. The worse the performance of IPs, the more the adjudicator may need to personally supervise the process, which in turn may cause inordinate delay. So what has happened in practice is the third paragraph. If there were positive developments, it could have been the second paragraph. But unfortunately, it is the third because of the performance of some of the IPs, because of the observations made by the regulators as well as the adjudicating authority in terms of negative perception about the performance of insolvency professionals. The regulations are becoming more and more stringent. The reporting requirements are being added every now and then. The result, many of the insolvency professionals feel that they are burdened with too much of reporting. On the other hand, the regulator thinks that because of this performance of some of the IPs, there is a need to regulate it more effectively. So in that process, those who are not the culprits also get affected because the rules will apply to all. And that's how you see in the first year, there was no form of reporting. Over a period of time, several forms were added. And now it is on the portal of IBBI. You have from IP1, Form CRP 1 to 8. And now recently they have also prescribed forms to be filed for even the liquidation process, compulsory as well as liquidation process. So there seems to be a sort of distrust or the need of more regulation to bring in either transparency or to see that everybody complies or does the work in the prescribed manner so that the results of IBC which are envisaged may be achieved. Consumers in a well-functioning market for IPs are likely to have greater trust in the overall insolvency resolution system. On the other hand, poor quality service and recurring instances of malpractice, fraud will erode the trust of the consumers. And BLRC also envisages one thing that the fees will be made transparent. It will be made public. Everybody will know about it. So the people at large or the industry at large will know the performance of an insolvency professional and the fee he had charged for it. And they can make a well-informed decision about whom to appoint, whom not to appoint. Earlier, this was not available, but now all the details about the insolvency professional's fee plus expenses incurred are available on the portals of the 3 insolvency professional agencies. Anybody can have a look at it. There's no restriction. It is for public at large. So that is in line with the objectives set by BLRC committee. Apart from the expectations or observations in the BLRC report, the first president of NCLT, Justice M.M. Kumar, also made a statement in one of the judgments regarding how important is the role of insolvency professionals, how important it is that the whole process is run in a very transparent and honest manner. Whenever a new dispensation comes into force, it brings about a large number of challenges. The parties to litigation make efforts to project a viewpoint suitable to each one of them, confronting the courts with the gigantic task of implementing the provisions of a new statute, rolling out of the new regime in a manner as to achieve its primary object. And here again, the role of IP is envisaged. If the IP functions efficiently and in a transparent manner, the job of adjudicating authority in terms of additional litigation gets reduced. This is in terms of a picture, how alluring it may be. When you have power, you have possibility of manipulations. This may be a big attraction to the insolvency professionals, but actually how they are required to function is like this. Though the ecosystem in which we operate is not very efficient, very honest, but the IP has to act like lotus in the muddy water. He has to be clean, he has to be transparent, he has to function effectively in a time-bound manner for resolution of the corporate data. So as we discussed the 4 pillars, out of the 4 pillars, IP is the most vulnerable. 2 being the government authorities like adjudicating authority and regulator. Information utility is again a private institution, but being in a position, it's almost a monopoly. There's only one information utility. So there's hardly any challenges to in such a situation. The only pillar which is considered as the fulcrum and the most important pillar is the vulnerable one, and which get affected by all the 3 other pillars. And the position can be described something like this. Working under challenges from different stakeholders, pulls and pressures from the stakeholders which can influence the process. A brief overview of the provisions of the code relating to the responsibilities or role of insolvency professional. This is just an overview of the provisions of the code. Section 17 deals with the management of the corporate data by IRP. That is the first stage. Section 18 describes the duties of interim resolution professional. Section 20 elaborates how the management of the corporate data is to be done as a going concern. Section 23 contains the provision that how RP is to conduct the CRP process. Section 25 is for duties of the resolution professional. So here, duties of IRP and RP are put in different sections. Section 128 is related to individual insolvency. And there it talks about what is the standard of conduct. That IRP self-performance functions and duties in compliance with the code of conduct provided under Section 208. So Section 208 is the main function which controls the functioning of main section which controls or regulates the functioning of insolvency professional. It is by virtue of this section and the powers given to IBBI that various regulations have been framed, like regulations relating to IP, regulations relating to IP agencies, and the code of conduct is part of the IP regulations. Section 207 and 9 are regarding the enrollment and registration of the insolvency professionals. So this is just a broad picture in terms of the provisions contained in the code of the role of insolvency professionals. These are the sections relating to regulation or disciplining the insolvency professional. Of course, these are common for IP agency and information utility as well. Section 217 to 220, and then 270 to 735A and 236, trial of offenses. These are the various roles which an insolvency professional can take under the code. That is like IRP, RP, liquidator, bankruptcy trustee. He can represent the financial creditor. He can represent any member of the committee of creditor. He can also act as an authorized representative. So there are various roles which the insolvency professional can take under the Insolvency and Bankruptcy Code. This is a brief overview of the key responsibilities of the insolvency professional. May I request someone to read this slide? Deepak ji, आप भी attend कर रहे हैं क्या?
Yes, sir. Yes, sir. This is key duties and responsibility of IP. So point 1 is taking over management control of CD. Second, verification of claims in case of large number of creditors, home buyers, fixed deposits, and organizing COC meetings, e-voting, audio-video recording with a large number of members representing without decision making, arranging interim finance to keep CD as going concern, and in valuation, different categories of assets including IPR, inventory, and debtors.
Arrange valuation. Sorry. Next one.
This preparation of
information memorandum.
And
okay, please go ahead.
Yeah, preparation of memorandum, information memorandum, and expression of interest and inviting resolution plan. Then examine each resolution plan to confirm that it does not contravene any of the provision of the law for the time being enforced. Then disclosure to IBBI, IPA, and reporting to NCLT, IBBI, and IPA.
Thank you, Deepak ji, for reading it. So this is a broad overview of the important functions of an insolvency professional, right from the admission of the CRP application till the resolution plan is approved by the adjudicating authority. We will discuss in detail these various functions with the help of important case laws to understand the implication of the law and how the IP can function effectively. As far as the role of IP is concerned, there were several details given in section 17, 25, 20 as to what the functioning of RP will be. But these three important responsibilities are the most challenging. That's why I just wanted to highlight them. The first one is the IRP shall be responsible for complying with the requirements under any law for the time being enforced. And that's a great responsibility. It's a big challenge. When the company is already under stress, there is a mandate to comply with the requirements of all the laws which are applicable to that corporate debtor. And the more important part is that in case there is a non-compliance and any penalty is imposed, that is not considered as the corporate insolvency resolution process cost. That is the personal cost of the insolvency professional. So one must be very careful while taking an assignment and fixing the fees, that what challenges he or she may have to face it. The second one is to protect and preserve the value of the property of the corporate debtor. It's an uphill task. The moment an insolvency is announced, the value goes down. Nobody can stop it. And more the time it takes in resolving, the value deteriorates. So it's a very, very challenging task which is given to the insolvency professional in terms of protecting and preserving the value of the property of the corporate debtor. And the third one is equally challenging. That is continued business operations. The IP shall be duty of bound to preserve and protect the assets of the corporate debtor, including the continued business operations of the same. Why the law is focusing on continuous operation of the CAD? How does it make a difference if the operations are not continued? Anyone from the participants, please? What is the relevance of this requirement in terms of the responsibility of IP? What happens if the business operations are not continued? What's the impact?
So it helps in the actually continuation of the going concern. It helps in the entire process of the wealth of these stakeholders is more intact compared to when the business is closed. So it is actually very important in that process. The basic objective of IBC, the maximization of wealth of the stakeholders, it really helps in the same process.
Thank you.
Well, I
In
think
fact,
as far as a resolution applicant is concerned, if the city is a going concern, then naturally, he or she would be able to invest probably, more money, and he will see more value into it. Basically, if the CD is going on.
true.
That's what it is.
If you see from different perspectives, in certain process industries, if you stop the process, restarting the process is a big challenge. It's a very costly affair. So they insist that the process, like particularly petrochem and other, where there is a continuous process, and once it stops, then cleaning of the machines and the restart will be a big costly affair. Second part is that maintenance cost increases when the machines are not being utilized, they lie idle. That will add to the maintenance cost. And, the most important part, as Mr. Katur informed, that if it is a running business, it brings a better value than a stopped production process. Or a very good example is SR Steel. You must have heard or read the success story of SR Steel. That's one of the star resolution process where almost 50,000 crore of creditors' money was recovered. Plus, the most important part in that was the efforts made by RP increase the actual capacity of production because of adding the balancing equipments or avoiding the hindrances. And the valuation was done on the basis of per metric ton. And that's how its valuation enhanced substantially. Nobody was even expecting that it will bring such a good valuation. And that one of the factors which contributed was that the business was continuing. Of course, it was a good business model. Plus, the efforts of RP made the increase the actual capacity of production. And that was, I think, one of the rarest examples of insolvency resolution, where the corporate debtor under stress made a huge profit of around 7,000 crore. It's unthinkable. When we talk about companies operating in stress, they hardly make profit or they incur losses. But that does not mean that you will have to continue with the committee of creditors can
So, your voice is breaking.
to discontinue, particularly if breaking. Okay, I'll put my video off. There's some problem with the connectivity. I hope that will improve slightly.
Now it is fine. Yeah.
Another challenge which brings in a sort of situation of conflict with the Committee of Creditors is Section 28. There are several actions or decisions which can be taken by the RP only after prior approval of the Committee of Creditors. So RP is not really independent in running the whole process of corporate insolvency resolution process. RP is subject to the guidance and supervision of Committee of Creditors in addition to adjudicating authority. And often it creates a situation of conflict between the COC and the RP. Because COC would try to influence the decisions of RP, which the RP is supposed to take independently. And there have been discussions and suggestions over a period of time to have a code of conduct for the Committee of Creditors as well. In fact, in one of the cases, Honorable Delhi High Court has also issued a direction to IBBI to come out with the guidelines for code of conduct of the Committee of Creditors. Because there are several instances where it has been found out that the COC is also not functioning very responsibly or effectively. So with this broad overview about the key responsibilities and challenging duties of insolvency professional, we proceed with the detailed discussion on various aspects. Any points to be made by the participants here? Or they want to share any of their...
So sometimes COC themselves are not aware about the IBC process. And they act like, they are very ignorant. And as you said, the code of conduct, since it is not in place yet for the COC, I mean, at least practically, I find it very difficult in one of my cases because they respond. For example, if we have a COC meeting today, then the decision is to be taken by voting. They don't vote for at least next 2 weeks time because they initially probably the application is not filed by them. See, the CARP application might have been filed by an operational creditor, and COC members, they know that probably the CD is not that valuable CD, and there is nothing that there won't be any resolution, and the COC members may not get anything. In that context, they act very, very differently. They don't want to go ahead with the process.
Yeah.
Yeah.
That's true. And because another dimension of this is like whether it is filed by the OC or any other FC, the resolution responsibility has been put on the Committee of Creditors. And was it disconnected in between?
No, sir.
Yes.
No, we can hear you. Hello?
That's in fact a very challenging situation and everybody is helpless. In fact, IBBI took a lead in amending the CRP regulations, and a regulation was added which talks about that IBBI to issue code of conduct for the Committee of Creditors. But unfortunately, the practical situation is that the banks are being regulated by RBI. So IBBI may not be able to have the legal teeth to regulate them, even through this IBC amendments. Of course, there have been talks between IBBI, IBB, IBA, and RBI since last 2-3 years in this, like how to regulate or how to put a code of conduct for Committee of Creditors. But as that has not still seen the light of the day. IBBI issued a discussion paper long back, and they listed about the code of conduct for committee of creditors that was similar to that of IPs, but that has not also been finalized for the region's appellate.
I think, sir, it could be made only by the regulator, means RBI, because IBBI, since technically
Yes.
it doesn't have teeth, so no meaning. It will not, because it is up to banks, whatever priorities are there, in
Yes.
case they won't think it prior, then it will not work in that.
That is true. And that's why it is lingering on.
Yes, sir. Yes, sir.
These are the few key challenges which an insolvency professionals face in terms of appointment and exit, sustainability of the IPs in terms of fee, in the timelines of payment, approval of COC, delayed at times, compliance and mandate, reporting mandate increasing day by day, litigation and non-cooperation. Litigation is endless. There are number of cases. Yes, I was to make a comment like the unfortunate situation is that we have made a law which is applicable to all, irrespective of the size and shape and the complexity of the business. A company having assets of 1 crore is also to run through the whole process like a company having 10,000 crore. And I've seen many cases initiated by operational creditors where there is no asset in the corporate debtor. The registered office is not traceable, and the cases are lingering, and IPs who have been appointed are unfortunate. They don't get their fees, and the whole process is in the limbo. So that's why, in fact, in PLRC, while talking about the fees of insolvency professional, they have made a mention that those who take good cases with high fees should also take up such cases where very little fee can be paid or no fee can be paid. So that was sort of balancing, but unfortunately that doesn't happen. The cream is always taken by big companies, and the individual insolvency professionals are settled with such type of corporate debtors with the less or no assets, and where the COC may pay very little fee, or even that fee is not paid, though approved by the COC. So this is the biggest challenge which the insolvency professional faces. Despite so much of the risk and challenge in the operations, the remuneration is not very sure in terms of quantum as well as timelines. And this is unique profession where there are two regulators. So the IPs have to face the regulatory action of both the regulators. In terms of laurels, or in terms of hype on the profession, it exercised the powers of board of directors. IP is vested with the management of the corporate data, is the custodian of property, manages the company as a going concern. And all these calls for the highest level of integrity, reputation, and character, which was indicated through that picture of lotus in the muddy water. IP has to function like that. The courts have also elaborated in terms of the role, high quality role of the insolvency professional. In a recent judgment of Delhi High Court, which was regarding the registration of an insolvency professional, rejected by IBBI, so that affected person went to the High Court challenging the decision of IBBI. So the High Court has narrated the importance of the function of IP in a very appropriate manner. Okay. May I read someone to read this slide? Vaishali,
So if you
would
if
like
you
to
know,
read?
anyone, so should I do it?
Yes, please go ahead.
Uh, it says an IP performs very important functions in the insolvency resolution process of a company. An IP virtually takes over the company during the period it goes through the insolvency resolution process. An IP, in fact, becomes the heart and brain of the company under the insolvency resolution process, and a person having slightest of disqualification cannot be permitted to be appointed as an IP. Otherwise, the entire process of the IBC will get vitiated.
Yes, thanks for reading. See, that
You must.
one paragraph highlights the importance of the role of insolvency professional. And that's why stringent process of registration of IPs is being adopted by IBBI. Initially, if some of you remember, if they have registered in 2016, there was no requirement of the limited insolvency examination. For 6 months after notification of IBC, it was like anyone having the required number of years of experience can apply, and he will be enrolled and registered as insolvency professional. Then the limited insolvency examination was introduced. Thereafter, the requirement of pre-registration and post-registration training was also added. And then the requirement of continuing professional education was added. So IBBI is in constant improvement in terms of keeping the capabilities of insolvency professionals, keeping them up to date with the latest amendments, latest judgments, so that they are able to function effectively. In the very first judgment of Supreme Court under IBC, that is Innovative Industries versus ICICI Bank, it is known for something else, that is the overriding powers of IBC under Section 238. But in terms of role of IP, highest or the apex court has also observed a very important thing, that once an insolvency professional is appointed to manage the company, the erstwhile directors who are no longer in the management obviously cannot maintain an appeal on behalf of the company. So it's a very important judgment in terms of the role of an IP. When the CRP process starts, it's the RP, it's the IRP who will be taking all the decisions and will lead the company, not the erstwhile directors. They don't have even power to file an appeal on behalf of the company. They can file appeal on behalf of the shareholders or themselves, not on behalf of the company. There it's only the insolvency professional who can represent the company henceforth. So that was one of the landmark judgments regarding the role of RP in the very beginning, way back in 2017. The next one is regarding the adjudicatory powers of RP. This was with reference to the process of claim verification. So the Honorable Supreme Court held that RP has no adjudicatory powers. RP is not a quasi-judicial or judicial authority. RP is only in an administrative position. And the functions of RP are overseen by the COC and the adjudicating authority. Of course, here the comparison was in terms of the duties and responsibilities or the powers of RP and the liquidator. though both are IPs, but in different positions. So while comparing the wordings used for both of them, the Honorable Supreme Court has held that RP is not an adjudicatory, having any adjudicatory power, whereas the liquidator has with reference to admission or rejection of the claim. And it is because of the specific words used in the powers of liquidator. We will also see the manifestation of this statement that RP doesn't have any adjudicatory power with the reference to the RP's role for resolution plan vetting. Because there also he has to decide whether the resolution plan complies with the laws for the time being in force or not. So if RP is not an adjudicatory authority, it can't do it. Versus judicial authority, it can't do it. First, we will focus only on this, which talks about the claim verification process. These are the details which the Honorable Apex Court examined while coming to that conclusion. Would like to read this in the following slide regarding this important assertion by the Honorable Supreme Court. Madam Vaishali, would you like to read?
Yes, sir. Under the
Please.
CIRP regulations, the RP has to vet and verify claims made and ultimately determine the amount of each claim as per regulation 10 to 14. RP is given administrative as opposed to the quasi-judicial powers. When RP is to make a determination of preferential transactions under regulation 35A, he is only to apply to the adjudicating authority for appropriate relief based on the determination made. In liquidation proceedings, under the code, has to consolidate and verify the claims and either admit or reject such claims under sections 38 to 40 of the code.
Yeah, please continue.
When the liquidator determines the value of the claims admitted under section 40, such determination is a decision which is quasi-judicial in nature and which can be appealed against the adjudicating authority under section 42 of the code. Unlike the liquidator, the RP cannot act in a number of matters without the approval of the COC under section 28 of the code. Which can, by a 2/3 majority, replace one RP with another in case they are unhappy with his performance. But
Yeah,
here,
thank you.
the liquidator can also be replaced, no?
Yes, now the provision is there, liquidator can be replaced. See, this, as I told you, this is one of the beginning judgments, Swiss ribbon, where the wires of the code were challenged.
Yes.
After that, there have been so many amendments, particularly with the reference to the liquidation process. Now, earlier, the stakeholder consultation committee's suggestions were not binding on the liquidator.
Yes.
The liquidator could have differed from the suggestions given by the stakeholder consultation committee, of course, by giving the reasons. But over a period of time, the amendments are being made in such a manner that the SCC is gaining the same position as the COC. And the liquidator's powers are being curtailed over a period of time. So it was based on the law at that point of time. There was no provision for replacement of liquidator then. So coming back to this key issue, Honorable Supreme Court has compared, like in the CRP regulation, where the role of RP is concerned, the words used were vet and verify claims. Whereas for the liquidator, it was verify the claims and either admit or reject. So the opinion or observation of Honorable Supreme Court was that since these words are missing in the CRP process duties of RP, the RP has no power to reject a claim. But practically, when the RP is not admitting a claim, he is rejecting it. The only words to be used carefully is that RP should never say that your claim is rejected. RP can say that based on your claim, he can ask for additional information, whatever is required, and he can say that, okay, based on your claim, I admit it for such and such amount, not the full amount. So that privilege is still there with the RP, but technically he can't say that he is rejecting a claim of a creditor because of this decision of Honorable Supreme Court.
So when we file the list of creditors, we should that unverified or rejected
no.
amount should be put in the under verification amount column?
No. See, there are columns in that list of creditors. It will say that what was the amount of claim made, what is the amount admitted, and then remarks as to what was the reason you did not admit the full amount. So it has to be very clear, transparent. You don't say you rejected it, but you will admit only what is supported by the relevant documents. Another important highlight made by Honorable Supreme Court here in terms of exercising the powers of RP is regarding applications to be filed for PUFE transactions. That is Regulation 35A. So here, Honorable Supreme Court has considered that this is only a determination. He is not adjudicating. It's not a judicial view. And if you remember, Section 29, Clause G, that is disqualification of the prospective resolution applicants on account of their role in PFU transaction in any corporate debtor. So one of the conditions there is that there should be an order of adjudicating authority, holding them responsible for PFU transactions. Then only they are disqualified. So filing of an application by an RP under Section 43, 45, 50 or 66 under Regulation 35A does not disqualify a person, because that is the RP's opinion, RP's determination. It has to be adjudicated by the adjudicating authority. Once the adjudicating authority confirms the finding of insolvency professional, then only such persons, directors, KMPs, are responsible or disqualified under Section 29A. Is that clear? I had crossed over to another subject because of this reference by Honorable Supreme Court. Is that clear what I mentioned about Section 29A?
Yes. Yes.
Okay, thank you. Again, I am just highlighting the observations of Supreme Court relating to the role of RP in various laws. This was Committee of Creditors of SR Steel. So Supreme Court here again observed RP's role also is to collect and collate and finally admit claims of all creditors, which must then be examined for payment in full or in part or not at all by the resolution applicant, and be finally negotiated and decided by the COC. So Honorable Supreme Court has summed up the whole process of claim verification and its importance and its results. But as far as the role of RP is concerned, it is in confirmation of Honorable Supreme Court's judgment in Swiss Ribbon that RP's role is only to collate and collect the claims, which is a basis for preparation of information memorandum and the resolution plan by the prospective resolution applicant.
Sir, may I ask a question? What are the meaning the last sentence by the resolution applicant and be finally negotiated and decided by the COC meaning?
You see, the resolution applicant will put up a plan.
This in the context of the claims received.
Yeah, that's
I
what I'm
think-
saying. In text of the
I
claim.
think it is in the context of payment, maybe, as per issue plan.
Say, the resolution applicant will propose X amount of payment against the claims.
Yes, yes, yes.
Okay.
RP will vet
This is-
the plan in terms of the mandatory contents, not in terms of quality. The COC will consider it, and then COC will negotiate whether it'll ask for a better payment terms, improve that. That's the negotiation which COC will have prior to approval.
of the plan. Yes.
नहीं खराब हो जाए नहीं टेस्ट सही है इन्होंने का नमक थोड़ा सा कम है पूछ लेना लग आप कुछ
I
डाल
hope it is clear.
इतनी ज्यादा तो इतना भी नहीं है कि वो करके कह रहा हूँ
He has to mute.
मुझे लग रहा है
May,
पता
may I
नहीं
request others to please mute the mic? So this is the whole process, how things will go. It is the role of COC to negotiate with the RA in terms of better offers. So like initially, the RA may say, I'll pay 50% of the liability of financial creditors. I'll pay X percentage of the operational creditors. And maybe COC negotiates and says, okay, you improve it on this account, you improve on this account. And that's the process of negotiation, which will result into a commonly acceptable amount for the resolution plan. And then the COC will approve it.
Got it, sir. Got it.
Thank you. Next one is, as we talked about section 29A, it is again on the role of RP. Section 30, subsection 2 talks about the mandatory contents of the resolution plan. Among that, that last one is more troublesome, which says that the resolution plan is in compliance with the provisions of law, or it doesn't contravene any provisions of the law. So when the Supreme Court has held that RP is not a quasi-judicial authority, RP cannot take such decision, then how can RP say conclusively that whether a plan is contravening or not contravening the provisions of the law? And to the rescue of RP's responsibility, the Honorable Supreme Court has held that RP's observation or RP's finding is prima facie opinion. That has to be given to COC. And COC is also not a quasi-judicial authority. COC can also not take a decision whether the law it is compliant with the law or not. So what will be the right course of action in that case? If the RP is of the opinion that the resolution plan contravenes a law, any law, in its due diligence report will report the matter to the COC. The COC then should approach the adjudicating authority for adjudication whether it is compliant or not, because the only judicial authority can decide. Commercial wisdom and the judicial interpretation are two different things. Commercial wisdom of COC is unquestionable, except under certain instances, but the COC cannot assume the judicial review power. And that's how Honorable Enclet has held in 63 Moon Technologies case that COC can use the commercial wisdom, but the COC cannot use the judicial power of interpretation. It is beyond its powers. So may I read someone to read this slide, which gives a better clarity about the issue involved here. Whom should I request? Mr. Prabhakar, if you are there. Anyone else?
Sir, may I read?
Yes, please.
The fact that the RP is also to confirm that a resolution plan does not contravene any of the provisions of the law for the time being in force, including section 29A of the code, only means that his prima facie opinion is to be given to the COC that a law has or has not been contravened. Section 30 subsection 2 subsection E does not empower the RP to decide whether the resolution plan does or does not contravene the provisions of law.
So this is thank you for reading, and this is an extension of Honorable Supreme Court judgment in Swiss Ribbon. It clarifies the role of RP, to what extent RP can act and to what extent it cannot act. The judgment of Honorable Supreme Court in case Sasidhar versus Indian Overseas Bank is known for what? Which principle was propounded in this case? We have discussed several times. Which principle was propounded by Honorable Supreme Court in this judgment? What is written in the slide is not
commercial wisdom of the COC.
Yes, thank you. This is the commercial wisdom. And in fact, after that, several judgments have reaffirmed the concept of commercial wisdom. But the concept of commercial wisdom was actually not propounded here. It was long back in Mofatlal case that was related to merger, demerger, and reorganization of companies. But that was with reference to the provision of Companies Act. Here it was with reference to the Insolvency and Bankruptcy Code, because the business decisions can be taken well by either the shareholders or, here in this case, Committee of Creditors, not by the courts. Courts should not intervene with the commercial wisdom of the Committee of Creditors. The issue which we are going to discuss here is related to insolvency professionals. In that judgment, Honorable Supreme Court also observed as to what the RP should not do. The RP is not required to express his opinion on matters within the domain of the financial creditors, to approve or reject the resolution plan under section 30, subsection 4 of the IB code. What does it mean?
Sir, in case we read this section with the 29A, I understand that in case any reso plan is contravening even the legally, then he has to express his opinion on that matter, but rejection and approval, he cannot say anything.
Yes. Earlier, that was in the initial period, because now the judicial pronouncement help us understand the interpretation. Earlier, the understanding was the RP has to confirm the feasibility and viability of the resolution plan. They used to appoint someone to assess the plans. The COC also used to say, we don't know anything. You review it and bring it to us for voting. Rest, all the things should be done by you. And then was this decision where a clear demarcation was done in terms of the duties of RP and the COC. RP's role is with reference to section 30, subsection 2. He has to see whether the resolution plan is compliant of the mandatory contents or not. But the commercial wisdom of the COC means the COC will look into the feasibility and viability of the resolution plan. So RP should never say you reject this plan or accept this plan. RP will only give his due diligence report that this is the report for this plan. And if RP finds that it is compliant of section 30 subsection 2, then it will place before COC for voting. This brings us to another area of the conflicting provisions in the code regarding the duty of RP with reference to the resolution plan. These are the two sections. Section 25(2)(I) says RP should present all resolution plan at the meeting of the committee of creditors. Whereas section 30 subsection 3 says the RP shall present to the committee of creditors for its approval such resolution plans which confirm the conditions referred to in section 30 subsection 2. So this creates a situation of conflict in the sense.
Yes, very well.
One section says the RP has to present all the plans at the meeting of the committee of creditors. Another says that which conform to the conditions of section 2. So what is the difference? If you read carefully, you will identify the difference.
Sir, on first 25(2)(1), he has to present all the plans whichever is received. And in 30 subclass 3, he has to analyze and present his whether all the plans are meeting the requirements.
This is a very glaring example of faulty drafting. But we can take shelter from the difference in the words. Like the first one only talks about presentation of the plans. The second one talks about seeking approval, presentation of plan for approval. So the inference is that those plans which are compliant will only be placed for approval of the COC. Rest all other plans will be not placed for approval, but it can be informed. So the best course of action for insolvency professional is that with his due diligence report, he will place all the plans. He will say that these plans are compliant with section 30 subsection 2. These plans are not compliant. So for the compliant plans will be put up for voting. So that's how the RP can manage the contradiction of these two sections. See, had it been a regulation, we could have said that the act will override the regulation. But here, these are the part of the act only, both the sections. The life of RP is full of dilemmas, conflicts, contradictions. There's another example in terms of valuation. What is the provision about valuation? One of the important responsibility of IP is to arrange valuation of the CD. So what is the provision?
Regulation 35, I believe, 27 and 35.
Yeah. What is that? If you brief the responsibility.
Appointment of registered valuer
Appointment.
regulation.
And
Am I audible, sir?
after
Appointment,
appointment is
Yes. appointment
yes,
is
yes,
regulation
you are
27.
audible. So how many valuers to be appointed?
Before the 47th
Two.
day of the ARP,
2 per category.
2 registered
per
valuers. It doesn't say per category, 2 registered valuers.
Yes,
But
again,
if there are more categories, we'll have to do 2 per the category only.
see the reason being, as we have seen with the judgment of Honorable Supreme Court, the law changes. The regulation regarding appointment of 2 valuers. Earlier, there was no requirement of IBBI registered valuers. Then it was added. Then there were categories added. There were 3 categories. So for each category, 2 valuers to be appointed. So before that categorization, it was only 2 valuers. Now it is 6 valuers. And if that is a value entity which have all the 3 types of valuers, then you can appoint this 2 valuer entities.
I think
No,
so. Category is not yet added. No category. I think the discussion paper is still on.
no,
In
category.
the regulation, there is no category. They don't mention.
In the regulation, there is no category.
Yeah. Because 47th day regulation. May I read the regulation, sir?
Yes, please. No, you are very clear. That is true. That's what I said. This is additional provisions made without changing the earlier provisions.
Precisely, the regulation don't say anything, but we can't. And we have to have it per category only. But yes, the regulation don't say anything about it.
There is a circular. I think there was a circular which was issued regarding this 3 categories.
Okay. Okay. So, any idea of the year of the circular, sir? Any idea?
I don't remember exactly. I'll find out and share with you.
Okay. Okay. Thanks. Thanks, sir. Thanks.
But so now I think the discussion paper is on with IBBI, wherein they are even proposing for appointing one single valuer for all classes, and if that particular valuer may require, he can appoint further valuers per category. This is what I think the discussion paper is going on now. Already, I think proposal is already on.
Even earlier, if the valuer entity had all the 3 types of valuers, could have appointed one valuer, but probably now they are adding that requirement of, if need be, they can appoint, because a glaring example is like jewelry. There are specialized valuers to value the jewelry, and there's no category of valuer. It is land and building, land and machinery, and financial assets. The jewelry is not a financial asset. So anyway, if there is a difference in the valuation of the 2 valuers, what the RP is supposed to do?
We have to go for third one.
And what
difference is more than 25%, significant difference is there, then only he is supposed to appoint a third one.
earlier, this substantial difference was not defined. And then people were taking like 10% or 15% variation, then you appoint a third valuer. But now it has been added in the regulation that what is a substantial difference, that is 25% or more. Now, what happens if there is a substantial difference, third valuer is appointed? Now there are 3 valuation reports, and you have to take average while submitting Form H, average of the fair value and the liquidation value. So which 2 of the valuations you will take for average? Will you take average of all the 3, or you will take the average of 2? If of the 2, which 2?
The nearest ones. The
Nearest one the 2.
Nearest ones.
Closest ones, yeah.
Yeah, the regulation says so, the closest ones. And that's here the issue of ambiguity for the insolvency professionals. In this case, a similar situation happened. Two valuers were appointed. The difference was substantial. Third valuer was appointed. So RP took the average of the two closest valuations, which were lower valuations. So Honorable NCLT directed that RP that since the overall object of the code is for value maximization, you should take the average of the two highest valuations. And that's how there is a judgment which is in difference with the regulations. So what will you do in that condition as an RP? What will you do as RP? The regulation says two closest, the adjudicating authority says two highest.
We will go with the regulation only. You know,
Probably the NCLT probably, sir. Normally we follow the regulation, but now we are told, I think so, probably NCLT.
See, this judgment was in challenge before Honorable Supreme Court for a different reason. And the Supreme Court has not intervened with the decision of NCLT regarding which average to be taken. So we can take a stand that Supreme Court has not intervened, so this we should follow. Let us see the details. Another important thing was decided by Supreme Court in this case was that earlier the impression of all the RPs was that the value of resolution plan should not be less than the liquidation value. That was the thumb rule. And it was understood that, yeah, that's the reason valuation is being done, so that the COC can take an informed decision. But in this case, Honorable Supreme Court held that there is nowhere in the code it is written that the resolution plan value should be equal to or more than the liquidation value. So it is the commercial wisdom. We leave it to the commercial wisdom of the COC. They know better. And that's how this was the case where Honorable Supreme Court held that the resolution plan can be of a value which is lower than the liquidation value. But we are referring only for the purpose of what average valuation RP should take while submitting Form H with the resolution plan approval application. And they have upheld the commercial wisdom of COC. These are the facts of that case. You see how substantial difference was there in the value. And the average valuation by two methods also had a difference of around 165 crores. So that's how Honorable Enclet was justified in saying that you take average. But unfortunately, incidentally, that was not of any worth because the Supreme Court said it doesn't matter which value. It is the decision of the COC that has to be honored.
So here in this case, the closest is the first two only, right? Because Vijay was 681 and P Madhu's 513 is the closest.
Here the clauses is this, but the RP had taken the average of these two.
So that is still validating the regulation only, right, sir?
Yeah. Still it will be in line with the regulation. The RP in this case had taken the average of this P Madhu and 12.
So then we go normally also by the NCLT ruling in our cases.
Yes. Yeah. If there is, if the highest valuations are not closest, then referring to this, we should go for the highest valuations.
And this was which case law? This was Maharashtra Seamless. Thank you, sir. Thanks.
Now the famous Venus judgment that was related to PFU applications. This is again Bhushan Steel. Since this was during the transition phase, before this regulation regarding timelines for filing application within 135 days for avoidance transactions came into effect. So in this case, the resolution plan was approved by the COC. It was submitted to the adjudicating authority for approval. Thereafter, the avoidance application was filed. And before adjudication on avoidance applications, the resolution plan was approved. And the RP continued to pursue the avoidance applications. So here, the Honorable Supreme High Court of Delhi gave a judgment which disturbed the insolvency regime. It said that PFU applications will not survive after the resolution plan is approved. So that was a jolt, because as such it is taking a lot of time in approving the resolution plan. If you mandate that resolution plan will be approved only and only after avoidance applications are decided, then the whole process will get delayed. And if we go by the decision of the Honorable High Court, resolution plan is approved, then the avoidance applications will not sustain. So the whole purpose of these provisions will be defeated. So in that, only with reference to RP, the Honorable High Court held that RP's role is finite. It can't continue to act on behalf of the CD after the new management takes over. Cannot wear the hat of former RP. And a review application was filed, LPA, by the Government of India and the affected party. And to the relief, the double bench set aside this judgment and held that RP will not be functus officio with respect to the adjudication of avoidance applications. The method and manner of RP's remuneration ought to be decided by the adjudicating authority itself. Because the approval of the remuneration for the RP is for the CRP period. Once the resolution plan is approved, the CRP period is over. Then who will decide? If the RP is to continue avoidance applications, then who is to decide? So there, the Honorable High Court has said that it will be the adjudicating authority which will decide the fees of the RP, and the RP can continue to pursue avoidance application. Of course, that is subject to the approval of COC. And that's why after this judgment, this RFRP and the resolution plan contains provision about who will pursue this avoidance application after the resolution plan is approved and it is handed over to the successful resolution application. There are some cases related to assignment of the not readily realizable assets that we'll discuss slightly later. Just remind me. So, would you like to take a brief break of 10 minutes before we continue? Or we can.
Yes, sir, we'll take a break.
As you're comfortable, so we can take a break.
So it is 3:30. So we start at 3:40.
Okay,
Yes.
sir. Perfect. Perfect. Okay.
So are you ready to start again?
Yes, sir.
I have given the circular details in the chat box regarding appointment of two valuers of each category. Another typical situation faced by during the CRP. Sorry. As we discussed earlier, SR Steel made a huge profit of around 7,000 crore during the CRP process. So the question was, who gets benefit of it? The creditors claimed that since they had to undergo haircuts, it's their right to have this money. On the contrary, the resolution applicant said that there was no provision in RFRP regarding this. So it should remain in the company. And if it remains in the company, who will get benefited out of it? If the profit remains in the company, who will get the benefit of it?
Resolution applicant.
Resolution applicant. So effectively, the plan value will get reduced. The money he was supposed to bring in will not be required. So at the cost of creditors, the SRA will get benefit. So after this incident, now the IPs in the COC have become wiser. So they have a provision in the plan which says that any profit earned during the CRP period will be shared by the creditors in a given proportion. And what happens if there is a loss? Who will bear it? If there is a loss during the CRP period, who will bear it?
Ultimately, SRI has to bring
The
in
COC.
Pardon?
And finally, the SRA. Yeah.
Unless there is a specific provision, it is the SRA, because he is taking over that corporate debtor as a going concern. So whatever is the status, the resolution plan talks about how much money he will pay to the creditors or how much money he brings in. So if there is a profit, provision is made in RFRP that will be shared with the creditors. If there is a loss, that is part of the CD. CD is taken over by the SRA. So would anyone like to read this slide?
RFRP issued in terms of Section 25 of the Code and consented to by ArcelorMittal and the COC had provided that distribution of profits made during the corporate insolvency process will not go towards payment of debts of any creditor, as per clause 7 of the first addendum to the RFRP dated 8th February 2018. On this short ground, this part of the judgment of the NCLAT is also incorrect.
So the SRA got the benefit. There was another interesting factor in this case itself. During the stage of EOI, SR Steel and Numetal both were disqualified on account of disqualification under Section 29A, Clause C. Clause C is regarding NPA. So the matter was before Honorable Supreme Court. Honorable Supreme Court said yes, RP was right in disqualifying them because of the default in payment. There are NPAs of a subsidiary company of both these resolution applicants. So using Article 142, Supreme Court gave opportunity that within a month you pay these dues and then qualify. 29AC, there is a benefit that if the defaulter pays the dues along with interest, then he can be qualified to submit a resolution plan. So just see the turn of events. Around 6,000 crore dues of Uttam Galva, a subsidiary of ArcelorMittal, had to be paid before ArcelorMittal became qualified. And they got a bonus in terms of this profit of the company. So it was a balancing act for them. RP has to be careful with reference to this judgment of Honorable Madras High Court. Under the Factories Act, an officer is appointed as occupier, and he is responsible for all compliances under the Factories Act. Whenever you take over a CD as IRP or RP, you should check as per the records who is the occupier and whether that person is still there or not. If that person is not there, then RP should appoint someone from the existing staff as the occupier who is in a senior position, else he'll be personally responsible. So in this case, what happened? The RP was hospitalized. During that period, got a notice regarding certain non-compliances. And after discharge from the hospital, those compliances were made. But in the meantime, prosecution was launched against the RP. So RP went to Honorable High Court to quash that. High Court denied to quash that proceedings. The only relief which the High Court gave was that since the RP has taken action after her discharge, those should be considered by the prosecuting authority. It should not be that they take action ignoring the developments after his discharge. So that also warns the insolvency professionals in terms of the liabilities which can come as a person who is in control of the corporate debtor. Mr. Rajesh ji, would you like to read these two slides of this judgment? If you are there. The problem is people are...
It's perfect.
Yes, please.
So it says the expression used in section 17 of the code explicitly say that the RP is the person who is vested with the absolute control of the corporate debtor company. While so, for the violation or omission in the factory premises, RP is responsible for the proceedings, if any, initiated against RP under the Factories Act in his capacity as occupier. The said proceedings will not be covered under section 14 or 233 of the code. The petitioner admits that he received notice but could not rectify the defects immediately due to his hospitalization. By the time he rectified the deficiencies and defect and intimated to the respondent, the sanction to prosecute has already been obtained. Therefore, this is not a case of denial of right, but failure to avail.
Fine. Last one.
Therefore, for the above said reasons, though it is not a case to quash the complaint, it is fit and proper case for the trial court to consider the rectification / compliance report of the petitioner dated 17th April 2021 for appreciation of the charge. Also, The subsequent events need not be ignored for the reason they are not referred to in the complaint or the sanction order.
Thank you for reading the long slides. So
Right.
here the key question was that RP tried to take protection under section 214 and 233. 14 is moratorium. So the moratorium provision in section 238 and 233. What is 233? You remember? Bona fide actions of the RP are protected. He is equated with that of the chairperson and the other employees of the board.
These are prosecution actions taken in good faith, sir.
Yes, yes. So the High Court rejected the plea that both these sections will not be of any avail. When we talk about IBC overriding other provisions, other courts, then the key issue is that whether there is a direct conflict in the provisions. That's the purpose of section 238. So here the moratorium provisions will not apply to the Factories Act so far as its compliance is concerned. So one has to be very, very careful. Regarding the powers of the board and the powers of the directors, what is the difference? When we say powers of the board are suspended, and when we say powers of a director are suspended, is it the same thing or something different? When the IP takes over, the powers of board are suspended. Does it mean it will suspend the powers of all the directors in whatever capacity they are working? I request the participants.
I think, sir, it will be suspended. All the, irrespective of their position, it will be suspended, right?
Any other opinion?
Sir, I think it is power of the board or directors with respect to whatever envisaged in the Companies Act.
Hmm.
But if he is working as a functionary, he will have to continue as a functionary, and responsibilities will not be suspended in that.
No, I'm talking about responsibilities will not be suspended. I'm talking about the powers.
Powers, whatever envisaged in the Companies Act, powers of the director, that will all be suspended.
That will all be
Suspended.
suspended.
Yes.
So here there is a conflict which was decided by Honorable Anklet. See, when we say board, it's a collective body. And there are certain powers which are vested in the board as a collective body, not as individuals. So that collective body functioning is suspended. The board doesn't enjoy that power. But if there is an executive director or there is a managing director which has been delegated certain powers, they will not be suspended. Otherwise, how he or she will function? The only thing is that such powers are to be exercised subject to the supervision and control of the IRP or RP. They can't disobey the RP. They have to continue. Like if there is a check signing power, they will continue, but subject to the control of the IRP or RP. Because here the corporate data has to be kept as a going concern. When IBC focuses on value maximization, it shows that the continuity should be maintained. So this was the case where Honorable Anklet decided, clarified that after appointment of the RP, the board of directors stands suspended, but does not amount to a suspension of a MD or any of the directors or officers or the employees of the CD. If one or the other officer or employee had the power to sign a check on behalf of the CD prior to the order of moratorium, such power does not stand suspended on suspension of the board of directors, nor can it be taken away by the RP. If the person empowered to sign checks refuses to function on the direction of RP or misuse the power, it is always open to the RP to take away such power after notice to the person concerned. So that's very...
But sir, in this case, MD who is having power of signing checks does any mischievous thing, then final responsibility will not lie upon the RP?
True. The last paragraph says that if he misuses the powers, then RP can come in. But it should not be at the first instance that the moment company comes. And that is particularly for large companies where a lot of staff operating, the operations are continuing. So if everything is disturbed in the beginning, then the going concern can get affected. So if there is a non-compliance or misuse, then it is always open for the RP.
It is to only facilitate RP to function well, I think.
Yes, yes, yes. This is regarding information memorandum. One of the key responsibilities of IP is to prepare information memorandum. The issue in this case was whether IP can modify the IM after the resolution plans are placed before the COC. Even before resolution plan receipt, there are reasons for RP to modify the IM. What could be such instances? Another example is claims. If there are additional claims, this has to be added in the information memorandum. And generally it is done by amending the IM and placing it before the on the website of the CD. So here the key issue was that after the resolution plans are received, and if there is a situation where the plans are to be called again, this is also an old case. IP doesn't have an authority to change it without the specific confirmation from the COC. If the COC allows, then the RP to prepare a revised information memorandum. This is also a judgment of Honorable Anklet, so one should be very careful. If there is a situation of revising the IM, then the resolution plans are placed, then it has to be with the approval of COC. Even otherwise, if there is a revision, the members of the COC have to be informed about it. That is the stage before placement of the resolution plan. Another clarification about attendance of the board of directors in the COC meeting. Way back 2018, 19, most of the IPs were under impression that whenever confidential issues are being discussed, the directors can be asked to move out of the meetings. And in one such case, the application was filed before the adjudicating authority. And it was held that since the law provides them with the right to attend, Section 24, subsection 3, notice has to be given to the directors, members of the board of directors, which was immediately at the time of CRP application admission. So you can't ask them to go out of the meeting. If there is something confidential, you can take confidentiality undertaking and they can continue. If they refuse to give confidentiality undertaking, then you can restrict. But otherwise, you don't have any right to ask the directors to move out of the meeting room if you are discussing any confidential issues. Similarly, most of the RPs had the understanding that the resolution plan should not be provided to the directors. So, Vijender Jain's case, Supreme Court held that since the directors are entitled to receive the notice of the meeting, notice of meeting means it should have the agenda and the detailed, all the documents which are placed before the COC. So you are under obligation to provide a copy of the resolution plan which is being considered by the committee of creditor. You can't restrict. Again, you can you have the confidentiality undertaking, and if the directors refuse, then you can refuse to provide. Otherwise, that resolution plan has to be provided to the directors also.
Can I ask you a doubt?
Yes, please.
So in case of board of directors, if you are sending them the notices and agenda, and say if there are 5 directors and a couple of them are not attending, okay, then after the meeting, as per regulation 24, the conduct of the COC meeting, you are supposed to send the minutes of the COC within 48 hours. So if 2 of the board of directors are not attending the meeting, am I supposed to send them the minutes, or I can, skip them?
You see, when they have right to attend the meeting, they have also a right to have the minutes, irrespective of the fact whether they attended or they didn't attend. That's the legal right which is contained in the code. When they are participants,
the regulation says to all the participants. So when you say participant is somebody who attended the meeting, right? Not necessarily the person who received.
You don't have to interpret it in that way. Participant is defined as the persons to whom the notice is to be given.
Okay.
Sir, I have another point here. Suppose suppose these promoters means suspended directors are one of the SRA. In that case, though we used to give the notice and agenda, and they have to attend the meeting, but while discussing the reso plan, should we keep it separate or ask them to to quit for a time being, or they should also, because they are one of the SRA, and in case we allow them to discuss the reso plan of others, they will certainly be benefited. So normally what I do for that part of a meeting, we requested them to quit, and they have also done so. But whether I don't know whether it is legally valid or not.
So it's a very tricky situation which you have handled nicely with the consent. But yes, otherwise, my personal understanding is that you can't. Because
I have forwarded the minutes also, but that part I kept as an annexer, which was not forwarded to that unsuccessful reso applicant who are the promoters.
You see, let us see a situation. When they are not SRA, you are sharing the resolution plans.
Everything. Yes. Well.
And you take a confidentiality undertaking.
Yes. They are ready to provide all the time.
So when you are placing it before the COC, that means the whole process is over. They have also given their plan. So they can't modify anything unless the COC gives an opportunity to modify it to the SRAs. So it is good that they agreed to move out of the meeting. But otherwise, if you infer these judgments of NCLT and Honorable Supreme Court, because they are participant. You can't ask
Exactly.
them to go out.
But
Had
in
it
that
been-
case, COC doesn't find it comfortable for them to discuss
That's
and
true.
negotiate. That is the problem.
That's true. That's true. So far as there is no conflict, it is okay.
It is okay. It is okay.
But
Once,
if they create a conflict and start
then certainly,
litigation, then is a problem.
yes, yes. Then problem. Okay.
That could be the commercial wisdom of the COC to request the SRA to move out.
No, they
That
will not
is-
do. They will ask you to do, sir. They will
That
never
is
do
the-
all those things.
That is the communication and people handling wisdom of the RP.
Yes, yes, yes. That is all RP who has to.
Sir, just a small thing. I missed just of last few lines of yours in the previous code when you're saying that the board of directors are suspended, but what about individual directors? So what was the final conclusion? I slightly missed that. I mean, it was somewhere a problem from my side. Can you tell me, sir, please?
I'll repeat that slide. If you read, this is very clear. That does not amount to a suspension of MD or any of the directors or officer or employee of the CD. But the only condition is that they have to work under the control and supervision of the IRP and RP. If they disobey, then the RP has to right to take away their powers.
So that's very right because they have their duties, but their powers are suspended. But you mean, I mean, with this, you mean to say that, for example, I mean, they can actually hold board meetings also, they can do other things also. Is that so?
Board meetings will not happen. When the board is suspended, how the board meetings will happen?
Okay. But the
It is
directors, otherwise,
contained,
the
yeah.
MD has his individual powers and he can use his powers.
But in one situation, again, there was a confusion about that. Like when the accounts are to be submitted to ROC, they have to be
Precisely,
approved
this is the point.
by the board. So in such cases, the RP will call the board meeting for the
Okay.
specific agenda. It will not be the normal board meetings to conduct the business of the corporate data. It is the specific requirements of approval of the accounts. There the RP will call the board meeting and then the directors will attend.
And he'll be present at the meeting also.
Yes.
But sir, I mean, this is exactly point I want to discuss because in majority of cases we've seen the directors refuse to sign on the balance sheet. So normally the RP is signing. They say we would not sign.
Yes, that is another art of communication and convincing by the RP. Initially, there was a lot of difficulty, like even the RPs were not ready to sign, saying that how we can take the responsibility. But when the RP is in a position of control, he can sign it with the notes like that. He was not there during that period, but by virtue of his position as RP, he has to sign. And IBBI's opinion was also that the RP should sign. The compromise was that both the directors will also sign and the RP will also sign.
Okay. And can the RP take any action if the directors are not ready to sign? Because this we've seen in almost 80% of the cases. They're not ready to sign.
What action you will take?
No,
What
no,
action you will
nothing.
take? You will add one more application before that NCLT.
Precisely. Precisely. Perfect, sir. Thank you, sir. Thank you very much. Thanks. Thanks.
That's right. They had also facilitated because the same problem was there for filing forms with ROC. They were not, it was the digital signature of directors and they were not cooperating.
Yeah.
So MC issued a notification that during CRP, all these forms can be filed with the digital signature of RP.
Madhusudan, that I just like to inform you that was my application. I mean, Oriental Bank of Commerce was a SICA under which they initiated the same.
Okay,
So
great.
thanks.
This was regarding one of the duties of RP is to prepare the eligibility conditions for inviting expression of interest and resolution plans. Now, this is a combined responsibility of RP and the COC. RP has to prepare the conditions and the COC has to approve. If there is a need, the COC can suggest amendments. So here, this was again a typical case. where the qualification criteria fixed in terms of net worth requirement were such that none of the T companies were fulfilling it. So they put application before the adjudicating authority that it has to be practical, prudent, rational. You can't restrict the participation of existing T companies. It was on two accounts. One is that the net worth requirement was put very high. And second thing was that the
Turnover.
experience criteria was not there, like existing T companies. So they said that it should be. NCLT passed order in their favor, but then the appeal was before NCLAT. And by that time, a very good response was received. Here, most of the bidders were expecting a bid of around 600 crores. And they got a offer from Dubai-based company for 1200 crores. And that was not a T company. And in terms of value maximization, that plan had to be accepted. But the basic issue is that since RP is given the power or responsibility to decide, it should be done in a very transparent manner, considering the business intricacies, considering the nature of the business, so that there is a maximum participation and competition among the resolution applicants. Just for your reference, you can read this assertions in terms of the observations by adjudicating authority. Who would like to read? Mr. Manjeet? Mr. Manjeet, if you're there, please read these two slides regarding eligibility criteria.
RP action should be prudent, practical, and rational, and such action must also demonstrate a clear correlation between such actions and the object it seeks to achieve. In the fact and circumstances of the case cannot escape being found enormously arbitrary and unreasonable. Eligibility criteria incorporated therein must ensure not only the quantitative competence but also qualitative competence of resolution applicants.
Please continue.
Since the decision by the RP and COC in finalizing the notice inviting EOI from prospective resolution applicants, PRA, suffers from the vice of arbitrariness, it violates the fundamental rights of the prospective resolution applicants, and as such, it requires to be interfered by this authority in the interest of all concerned. The above revelation, in my considered opinion, serve to show that the criteria so fixed in the notice to invite EOI from the PRAs cannot escape being found arbitrary, unreasonable, and therefore unsustainable in law, thereby offering this authority a ground to invoke its extraordinary jurisdiction to rectify the illegalities so noticed.
Thank you. Thank you, Manjeet, for reading it. So these were some of the important case laws about how the RP should function.
Sir, may I ask one question?
Anji, please.
Sir, the company was sold as going concern in liquidation. And
Company
then
was sold as a going concerned in liquidation. Okay.
liquidation. And in the process, and finally, there was a loss incurred during the liquidation process. So in that case, who will bear the loss?
when you say it was sold as a going concern,
Yes, sir.
the going concern means what? Goes with the
Actually, there were
law
employees in the
level.
company
Hmm.
to protect their interest and to take the company as a going concern. The IP has taken a decision to take the company as a going concern and sold it as a going concern. But in the process, there was a loss.
What was the terms for this going concern? Because when you're selling, you are defining it clearly as to what assets and liabilities will go, what assets and liability will remain. And when you are selling it as a going concern, you are giving the whole company, isn't
Yes,
it?
sir. Yes, sir.
The only thing is that you are identifying the money received will be paid to the specified creditors as per the waterfall arrangement under section 53.
Yes, sir.
So that will all depend on what was your terms
Yes,
as
sir.
to what things you will exclude, what things you will not include. Because when it is a going concern, like we have seen in the case of CRP, if there is a loss, it goes with the company. If there is a profit, it goes with the company unless there is a specific provision to deal with it.
Okay.
Is it okay?
Okay, sir. Okay, sir.
Would you like to discuss the case laws related to disciplinary cases on IP?
Sure, sir.
Hmm?
Yes, sir.
Sure, sure.
This is regarding the constitution of disciplinary committee. The wordings are such that it says full-time members. So there are two things. It can't be the chairperson because chairperson is not a whole-time director, whole-time member. The second thing is there has to be at least 2 members. Single member cannot constitute. So this writ petition before Honorable Gujarat High Court, the plea was that since the section 222 talks about full-time members, then there has to be at least 2 members in the disciplinary committee. A single member cannot constitute a disciplinary committee. And that on that justification, Honorable High Court has stayed the order of DC. In another case before Bombay High Court, the issue agitated was whether chairman, single chairman can constitute the DC. So there also the debate was whether chairman and whole-time members are the same. And the provisions in the code says that it has to be the full-time members, then the chairman cannot be the DC member. So Mumbai High Court has also stayed the DC action in that case. Final orders are yet to come. And probably if there is a final decision, it will be before appeal. But as the readings of the definition, it makes very clear that chairperson cannot be the member of DC committee, and the DC committee has to be constituted of at least more than one members. This is a very big relief to the insolvency professionals. There was another case in Delhi High Court where the RP took the position as a member of monitoring agency after the resolution plan was approved. And an adverse order was passed against the insolvency professional that you are violating the provisions of Code of Conduct. Again, the defense taken by the insolvency professional was that since his appointment as a member of monitoring agency was part of the resolution plan was approved by the COC and then adjudicating authority. And after approval of the resolution plan, by virtue of Section 31, it is binding on all stakeholders. And that was not his choice. It was the RA, it contained in the COC, resolution plan, approved, the adjudicating authority also approved. So again, this DC order was stayed. Fortunately, IBB had issued a circular after that, clarifying that IP can take position as a member of monitoring agency, subject to the approval of the COC. And there was another provision. There's one section in the individual insolvency which clearly says that the repayment plan will be supervised by the insolvency professional, RP. So there was no reason why RP in the CIRP process cannot be part of the monitoring agency for implementation of the resolution plan. That was in the Mahendra Khandelwal's case. So later on, a circular was also issued by IBBI, and that clarification was issued. So these type of judgments are helping RPs from some of the rigorous actions being taken by the IBBI. There was a conflict in terms of disciplinary process. Once it starts, can the adjudicating authority stop that process? So in this case, the DC was initiated on the direction of adjudicating authority. After that, the RP put up his explanation, and the adjudicating authority was satisfied that disciplinary action is not warranted. So adjudicating authority directed IBBI to stop the disciplinary process. But IBBI said no. Once the disciplinary process starts, it is the IBBI which will stop the process after its findings. The adjudicating authority can't intervene. And the matter was before Honorable NCLT. NCLT also upheld the right of IBBI, saying that AA can direct IBBI to initiate DC, but AA cannot direct IBBI to stop the DC. Once it starts, then it is the privilege of IBBI. After completing its due process, then only the IBBI will close. But as a matter of advice, it referred that since the DC was initiated on the recommendation of AA, and now AA is satisfied, this DC, IBBI may consider stopping this DC, and then IBBI also considered, and the DC was stopped. But it upholds one provision clearly that no one can intervene in the process of DC by IBBI. Even the writ jurisdiction will lie only after the IBBI has come out with the order. Some of the people tried to challenge the DC action, in the high courts, but then high courts refuse. They're saying that you come to us only when you are aggrieved. We can't stall the process. Let the IBBI complete the process, do its findings, and come with an order. And if you are aggrieved, then come for relief, but not to stop the process. So that part regarding the IBBI's power of disciplinary action against the insolvency professionals.
So just a point on this. Just now you say that this was while admitting the CRP application name of the IRP was written wrongly. I just want to ask you, sir, in one of the personal guarantor cases, my name is Rajesh Ramnani. It is mentioned Rajesh Ramani. So necessary intimation has been given to anybody. Does it need to be rectified from an application to be filed for the same, or it is okay and we can go ahead with the same?
Your registration number is correct?
Everything is, the other things are correct.
See, you can still ask for correction, but in this case, the IP didn't take any action. And that's why
Which one?
the adjudicating authority was annoyed. This
Okay.
RP case. So the
Mhm.
best course of action is that if your registration number is correct, means your identity is correct, it's only
Yes.
the typo error. So you
Yes.
can request for correction, but
Yeah.
continue your timelines.
Initiate the action and simultaneously file.
But correction should be told because I have not yet filed the application. So should I file the application? That's a must, or
Sir,
can I
sure,
avoid
sure.
also?
No, that
It's
is
better.
file, I think.
Better.
It's better.
Because it's a matter of record everywhere.
I get
Even
the
for you, like in case of individual insolvency, it is not a question of operating bank accounts. But in the CIRP, it is. When you approach the banker, they will object. आपका नाम ठीक नहीं है.
Yes, I
They
get
will
the point.
find any reason. So
I
it
get
is a
Better.
matter of practice to correct
But
the
in
record.
the second line, it is mentioned IRP filed the application for name correction. They referred the matter to IBBA for disciplinary action. May I know why the disciplinary action AA proposed?
Yeah, actually, he didn't take any action.
The
He would
IRP
have
filed
waited by that.
application for
Yeah.
name correction also. Yeah.
Like this publication of notice within 3 days.
Okay.
And the registration number was correct. It was only his name which was not spelled correctly.
Okay, sir.
Another interesting case, like this is the example of where two disciplinary authorities are there with concurrent jurisdiction. Recently, there's another judgment of Mumbai High Court in Amit Gupta versus IBBI, where the High Court has directed that for the same thing, you can't issue two so-called notices. And another issue was regarding this AFA. When there is a DC notice, the AFA gets suspended. So that's very unfair for the insolvency professionals. So the High Court adversely commented on it. But they said since this was not the issue before us, we can't pass an order regarding this. But the IBBI should look into it. Because unless you are held guilty, how you can be punished? Because the moment there is a notice does not mean that finally you are found guilty and there is some action against you. So the AFA remains suspended and you can't get another assignment. So in this case, what has happened? The disciplinary committee, instead of passing a final order regarding penalties to be imposed, they referred the matter to IBBI for further considerations. IBBI returned it, saying that you have to pass the order. You can only ask us for additional action if it's be taken by. And then the DC changed its order. So that was challenged. The appellate authority held that once you pass your order, you can't change it. You don't have any authority to change it. And another mistake done by DC was that normally the DC orders will be applicable after a lapse of 30 days. But in that order, it was written as order will be effective immediately. So these were the grounds on which the DC order was challenged, and the appellate panel set aside the order of DC. You can read this 2 slides if any one of you. Mr. Sunil, would you like to read? Mr. Sunil Agarwal or Sunil Choraria?
Yes.
Choraria, okay. You can do that.
Yes, sir.
Mhm.
I read this one. Three
Yeah,
so-called.
please read.
Yeah,
Yes.
yeah. The order of ICSI appellate panel. So it says that 3 so-called notices were issued. DC order passed on 14th December 2020, which says that DC, after considering the seriousness of violations, deems it fit to refer the matter to IBBI for final decision. The order should come into force from the date of its issue. That you were telling that since it is from the current date, so the matter was referred. Usually in courts of action, it is 30 days from the date of the orders. So IBBI replied on 25th December that DC has to reach a decision for action. DC is not precluded from making any reference for additional action by IBBI under clause 24(2)(e) of the model bylaws. So DC passed another order on 19 January imposing penalty of 2 lakhs and cost 50,000, suspension for 1 year, along with 50 hours pre-registration training. So
Yeah, please continue.
So the appellate panel held that the DC is discharging the function like a quasi-judicial body, is not bound by the directions of any external agency, exception being this appellate panel or a competent judicial forum. It also says that DC has no power to review its own decision. So the DC order effective from the date of orders, but as per regulation, order to be effective after 30 days. Next page.
So
yeah,
this was a very rare type of case of settling between IBBI and the IPA. The outcome or the lesson from this case is that DC should have its final findings and decision. It may refer to IBBI for additional action, but it can't just say to IBBI that you decide what action is to be taken on that. Another mistake was done that regulation says that DC order will be effective after 30 days. So that is for the opportunity of giving appeal against the order. And here the DC again made a mistake that saying that the order will be effective immediately. And on these grounds, appellate held that DC can't review its own order. That power is not given by the regulations.
There was another slide also, sir. We missed, I suppose.
Pardon?
There was another slide also which we came back. There was one more slide, I suppose.
This one.
After this, next slide.
75, page 75.
That is a different case.
Okay.
That is a different case. These are regarding the adverse observations against RP. So the basic thing is that it is again based on a Supreme Court judgment that unless required, you should not pass adverse order against the professionals. That was with reference to advocate. Here it is IP. And the second thing was that if it is required, then you have to give a opportunity of hearing, advance notice. Normally what happens, most of the adjudicating authorities, they just pass strictures against IP like that without giving any opportunity of being heard. So NCLET has set aside several such orders, saying that you should give a notice and you should give opportunity of explaining his case before the adjudicating authority passes any adverse remarks or strictures against the insolvency professional. So this is for the defense, for your protection, that in case such type of remarks are passed against you, you can take a defense. These, there was a writ against IBBI for this dual regulators. So the High Court said there's nothing wrong in that. Even the regulation regarding authorization for assignment and sharing 0.25% of fees with IBBI was challenged. But that was also dismissed by the Honorable Madras High Court. Observed that existence of more than one authority with regulatory or disciplinary power over a professional body is per se not a ground to hold that the impugned regulations are unconstitutional. So this has been upheld. IBBI is and the IP's power to regulate the regulations to the insolvency professionals. Regarding this, now this is increased to 1% of the fee. So this was also upheld by Madras High Court, saying that conferment of the power to charge a fee and the charging of such fee by using the annual remuneration as a main measure does not amount to delegation of an essential legislative function. So both the writs were dismissed. Recently, IBBI has also issued a circular regarding uploading the orders of NCLT on the website. So this was also challenged in Honorable Supreme Court, and the Supreme Court has issued a notice to IBBI. It is still sub judice. It was regarding the ambiguity plus retrospective orders, because it has been held in Uni-Value project as well as this IBBI versus Amit Gupta case, that IBBI cannot frame any regulations which are retrospective in effect. It can only make prospective regulations, and the NCLT as well as NCLET also cannot make retrospective regulations. They have to be prospective because they are a delegated authority to make regulations. It is not the parliament or the central government. So these are all the major case laws, and now we can discuss any of the issues which you have, or if you want to share experience in your cases. And nobody is visible. Everybody has put off the video. Was it of use and interesting, the cases we discussed?
Yes, sir.
Yes, sir. Yes, sir.
Would you like to add anything to that? Only 5 people are visible out of 22.
Sir, my video is not working, sir,
Okay.
but I'm there.
Sir, I am
Am I-
also there. My video facing issues, sir.
No, it's okay. See, the problem of the speaker is that unless you see someone, you are not comfortable communicating. At times, it looks like that you doubt whether people are listening
Listening or not.
or not. How's Aishwarya?
I'm fine here.
Any questions, queries, or any issues related to the case laws which we discussed? There are too many. I don't want to burden you with so many things. Okay, just one thing I remembered. We had talked about NRRA. Not readily realizable assets. So in the liquidation regulations, regulation 37 was added to facilitate timely completion of the liquidation process, where there are some assets which can't be sold off easily. So you can assign them and close the liquidation process. So with reference to avoidance transactions, incidentally, in some of the cases, NCLT had a very strong view that without adjudication of the avoidance applications, these can't be assigned. So first, there has to be a decision by the adjudicating authority as to how much amount is actually coming back to the corporate debtor. Then only you can assign. And that was a very difficult proposition because avoidance application takes a lot of time. These are not decided easily. So that will keep the whole process running. The liquidation, it will add to the cost of liquidators' fees and other liquidation process cost. But finally, the NCLT has accepted that even in case of avoidance applications, the same can be assigned and the liquidation process can be closed. Because if you read the explanation to regulation 37 of the liquidation regulations, it talks very clearly about the avoidance applications also. So there was no point of rejecting assignment of avoidance applications to close the liquidation process.
Case law, sir? Is there any case law in that regard?
Just a minute. Hold on. Are you able to hear? Are you able to read
Yes, sir.
this?
Yes, sir.
Yes, Ritu Tandon.
Yeah, this was the first case where unfortunately it was rejected. Probably it was because of the doubt in the minds of adjudicating authority on the terms of NRRA. Because if you read this paragraph, it says, not readily realizable assets of CD worth 26 crore for a paltry sum of 50,000. So that created the doubts in the mind of adjudicating authority. Of course, it depends on the quality of assets. Maybe there are receivables which are not worth it, this adding to the numbers. But that was the situation. So this was the judgment. If you can read the final paragraph, this will clarify. This does not mean that the debt can never be assigned. Once the demand is crystallized or determined, in other words, when the avoidance of PFU proceedings are concluded, the debt can be assigned by following the due procedure prescribed under the law. In other words, the cause to pursue avoidance application cannot be transferred or assigned by the liquidator. Only the assets crystallized in terms of order passed in the avoidance applications can be assigned or transferred to a third party. This was on the contention that since as per the IBC, only RP and the liquidator can file such applications, third party cannot have any locus to continue the applications. There are several judgments on this issue. Finally,
Sir, in this regard, I have one query related to one of my assignment. I am at the verge of completing the sale of entire assets under liquidation.
okay.
And and the company was the listed one, but during CIRP it was delisted, because as a RP I had used to submit all these quarterly reports to SEBI or SEC. So subsequently it was delisted. So now one of the RP or one of the advocate is asking me that since I have sold all the assets, I can file the dissolution. So that is okay, but he's telling since company has no assets, he may ask me to sell the company as a going concern so that he can file a case before this BSE and NSE that during CIRP as moratorium there, they cannot delist. And thereafter you can sell me the company. So I am, since as a liquidation process, I have to close it as soon as possible. Though I am reluctant, but can I do so? Or if I get it dissolved and file a dissolution application, any person cannot go into court that I am not maximizing the value. So what should I do that I am still in a little dilemma?
I missed your first part. Who is suggesting you to?
Means one of the prospective buyer is and who is means associated with an advocate also, that he is ready to give me a letter that I am willing to buy this company as a going concern, so that he could file a case in NCLT also, because I have no money to file. Why should I, since all the property are sold? So that I can publish a advertisement for selling company as a going concern, because his interest is, he based on that moratorium section 14, first he apply for means avoidance of delisting, get it listed, and then he can buy. That is the issue.
Unless we see the facts, it will be difficult to say anything. But
no, because company doesn't have any assets at all.
If there is no assets and it is
Yes.
already delisted, then why he wants to get it listed again?
Because sir, now as on date, the listed companies have a higher cost, and he is ready to pay rupees, means some amount he is ready to pay when I go for publishing the advertisement.
But in what capacity? You have already sold all the assets?
No, assets are sold, but I have yet to file application for dissolution in NCLT.
Yeah.
So prior to that, he wants that because he may pay also 1 crore or so, whatever. So he is ready to pay. He is telling that he is giving me a letter, and you may place it before SEC and seek permission, and then I'm ready to spend, and burden also will not be of yours. It will be borne by us, and then after seeking NCLT permission, you can sell it out to us and publish an advertisement. I'm ready to buy, and based on the
whatever details you provide, I feel it's a sort of fishy arrangement.
Okay,
so one must
okay.
it.
So because I am, since my job is to liquidate it as soon as possible. So when assets are sold and that listed or other things has not given any value, so it hardly matters me. I have go and close for liquidation. That is my point.
very strange situations the RPs face or the liquidators
Yeah,
face.
exactly. So only my apprehension is tomorrow nobody can, either bank person or so, anybody can go and sit in the court. You see, there was an offer, and but RT did not do, a liquidator did not do so, and he has filed the dissolution.
But
That
is
is the
it
only thing.
legally sustainable offer? Is there any provision in the liquidation regulations that after you
Not-
have sold all the assets, somebody can come? What is going concern status?
As a going concern, the only thing he is willing to buy as a going concern,
Is there
for
anything?
which we have to, as per law, after commencement of liquidation, I can go for liquidation at once, not thereafter, which I have already gone, and which is I have done during the process. And subsequently, since it not activated, so I have in the process of selling assets, and all the assets are sold except one very smaller one.
Any that you have assigned the smaller asset?
Yes, that one means the property is in seed. The company was in seeds. So one basement is there where I had kept the inventory. Now inventory is also sold. That basement valuing rupees 1 crore or so is only there, which can be which I will for which I have given the advertisement, and which also gets sold in a 15 days or so.
Then nothing is there.
Nothing thereafter. Nothing would be there.
Any of the participants would like to share on this, if they have
any type of experience also?
Yes. That is the value addition by the participants. So unless any query, then we can close the session. It has been a long session for 3 years, 3 hours continuous.
Continuous. It's up to you for speaking for answer time.
Thank you.
Very, very interactive section, sir. Very nice.
Thank you, sir. Thank you, sir.
Thank you.
Thank you,
Thank
sir.
you, sir.
Thank you, sir.
Thank
you,
Very
sir.
good session, sir.
Thank you.
Thanks to all of you for supporting me in reading out these slides. So Anjali, if you're there.
Yes, sir. Thank you very much, sir, for such an insightful and interactive session. Sir, please share the PPTs for the session.
I'll share.
Yes, sir.
Thank you. Thanks to all.
Thank you.
Thank you.
Thank you very much, sir. Thanks.
Sir.